Cancel your weekend plans and order some takeout. Your client needs an injunction. Preliminary injunctions and the temporary restraining orders that often precede them present a tough challenge. The matter at hand is probably crucial to your client, potentially putting their business at stake, and yet you have precious little time to do the work. Whether you're a seasoned litigator or a junior one, this is one of the hardest parts of litigation practice. When you're moving for a preliminary injunction, submit the following things along with your brief: the complaint, affidavits and exhibits, and the proposed order. Because of the time pressure, it's easy to spend a lot of time on the motion and wind up with a thin complaint. That would be a mistake, since the judge will rely on your complaint in assessing the claim's likelihood of success. It's important that your complaint be as detailed as possible, as opposed to in a regular case where you might keep the complaint general so the case theory could evolve through discovery. In our engineer case, for example, if you weren't moving for a PI, you might allege simply that the engineer took proprietary files from the plaintiff and wait until discovery to determine exactly what was taken. Since you are seeking an injunction, though, you should include all the detail you can about which files were taken and how you know that. You can always seek to amend your complaint later if your understanding changes. You can also file a verified complaint. This signals strength because the plaintiff is willing to swear to the truth of the allegations under penalty of perjury. It also means that any statement in the complaint can be considered as evidence as opposed to a mere allegation. But a compelling complaint won't be enough to get the court to grant this extraordinary relief. You'll need to present admissible evidence to show that your motion has merit. Usually, you do this through affidavits with supporting exhibits. For example, to support your allegation of stolen trade secrets, you could submit an affidavit from your client's IT person stating that the defendant copied files from her computer before leaving the company. When you're drafting the proposed order, be specific about the injunction you want. Make sure to include what specific activities are barred or required, who it applies to, for example, the defendant, its agents, and successors, and how long it lasts. Normally, it's until the case is decided. Be sure the injunction you're asking for is tailored to prevent the harm. It would be reasonable, for example, to restrict the engineer from sharing the proprietary technology with her new company, but may be too broad to say she can't do any work on microchips. If the proposed restrictions are too broad, the court could deny the motion or write its own narrower injunction. The party opposing the injunction doesn't have as much to prepare. Besides their opposition brief, the main thing for them is affidavits supporting their arguments.